Yeah.
Yeah, just the printout, yeah. Are you a role?
No, we just know this. Yeah.
I'm with you. The professor said I'm with you. So,
You told me we were in the
Against
middle.
are you in Nicole as well?
No,
Well,
we're against each
I'm
other.
a teacher, but I'm.
Yes.
I think it's
Oh, there's a teacher for and a teacher against.
Yeah. Professor,
Okay, I'm just gonna summarize where we are at.
does he have a role? You said he's a teacher, but which one?
He
For
can
or
be
against?
with you.
Okay, so we're for it.
So we left off sort of in the middle of exercise 2, where we had a group of parents, teachers, and students debating whether the article of free speech should be published in the school newspaper. So again, the students are to my right. We have, and Michael, you can join, Michael, John, and Joe are, refresh my memory, for or against publication, Joe, of free speech?
In the newspaper?
Yes.
You're against it?
You're against. And then Jonathan and Jennifer for publication. Then I've got a few teachers, and Todd is joining the group. So Todd and Nicole are teachers that are for publication.
We're for it, yes.
For publication, Laura alone is the teacher that's against publication. And she was the, again, you were the advisor to the after-school kids that put this newspaper together. I only have one parent group. I'm not sure if Jen's going to show up or not. The two Amandas are a parent group that is against publication of free speech. When we finish this up, you're going to actually flip them over for the third exercise, number 3, and I just crossed out what we did the other day and gave you roles for number 3. But I'll explain that piece when we get to it. Okay? Where were we at the other day? Laura, I think you were in the middle of something as the teacher that was advising the students, and you felt that
Yes.
this should not be published.
So,
okay.
I am against it, and my analogy was that this is just like the yearbook.
That's right, you were talking about a yearbook, and I think I had a question about that. Whether the yearbook was like a public forum, and I know that Nicole and Todd might want to address that as well. If it's like a yearbook, does that make it a school-sponsored kind of publication? I don't know. Is that what you were addressing?
That's right. Yes, that I do believe, even though it was slightly distinguished from one of the prior cases in that it was part of their curriculum, this is a school-sponsored, the publication of this newspaper, I believe, is a school-sponsored process, in that my stipend is paid by the board, the supplies are paid for by the board. It bears this seal of the school, and part of the newspaper is that I'm supposed to help the students with their journalism, with learning what fairness is and how to edit. That's part of the objective I've been given in publishing this newspaper. So, I can't divorce it from a school-sponsored activity in my opinion.
I'm still uncertain about the school's control. And so on the one hand, I'm worried about that particular issue. And then the other thing that I was thinking of as well is, does this article have any kind of value in terms of, and I guess I could ask the students that are for it, is it literary, artistic, political, scientific? Does it have any kind of value? What's the purpose behind if the administration decided, okay, we'll go on and publish it? Jonathan, you look like you want to answer that.
No, I was going to say it was just, I guess it could fall under artistic, under the view or perception of the writer. So it would fall under the writer's free speech, and so it should be able to go into the newspaper and be published.
So somebody respond to that, because then the question is, does the deletion of this article then violate the students' freedom of expression goal?
Under the chapter 71, section 82 in
Mhm.
the law, it deals with the rights to students on freedom of expression. And the section basically states that the school cannot take away their right as long as it doesn't cause any disruption or disorder within the school. And the freedom of expression that's included without limitation is to write, publish, and disseminate their views.
So that's the question, right, it's quoting right from the statute to section B, write, publish, disseminate their views. Is it really, if this article gets published in this newspaper that Laura is saying, that, you know, she's an employee of the school, she stays after school, she gets a stipend for it, she says the school supplies they use and so forth, does it then become not necessarily just the view of, you know, Hallie Wright, one of the students involved, or does it look like it's the views, you know, of the school? Todd?
I would take this, if you were gonna read it that way, in relation to the case of Hazelwood School
Right,
District versus
right.
Kuhlmeyer, where the discussion revolved around, was it in a public forum situation? And although the faculty member who's working on the school newspaper gets a stipend, is differentiated from the Kuhlmeyer, Hazelwood versus Kuhlmeyer case, it was the students in question, whether they were getting credit for writing this paper. In this instance, where free speech is wanting to be published in the school newspaper, and it does not appear that the student is being given credit, notwithstanding the staff member getting a stipend,
Okay.
it appears like one could argue that this school newspaper is within the public forum, and therefore the student is expressing his viewpoints under the First Amendment.
Can I hear from the parents?
Yeah. The question about whether it is a school-sponsored event or not is one that needs to be decided. So if the teacher is receiving a stipend and the teacher obviously oversees the newspaper, they have some input as to the outcome of the article that would be in the paper that the children are doing after school. And therefore, it is an extension of the school curriculum in that respect, so it would be a school-sponsored event.
One case that no one has brought up yet, and I guess I'll bring it up now to discuss as well, is the Heiko case. And I can't remember if we got into it the other day within the context of this discussion. And I guess my question is the school looking to censure this, to delete this article, as Laura, the teacher, is proposing here, just because the school dislikes the ideas contained in, you know, in that article? Again, me being a member of the administration concerned about liability, will I be, you know, will we be, the school be violating the students' constitutional rights if we end up deleting this article? Because isn't that what this is about, really? That Laura brought it up, but there was, you know, again, being the teacher here, but also we've got a group of students and a group of parents agreeing with her that this article should be deleted. I mean, is it necessarily because that these three groups don't like what's in there? Amanda, Sarah?
I think, yeah, I think that the school has a duty to protect against disruption or controversy, and I think that an article with this type of language in it could cause such chaos, and I don't think it should be published.
Okay, but that wasn't my question. That is a very good argument. But my question went to, you know, the Pico case, that, you know, of course it was an older case, and at that time it was books that certainly are on the shelves today. But the holding in Pico went to, you know, the idea that schools can't necessarily just censure because they dislike, because the school administration dislikes the ideas contained in those books. You know, going back to Tinker as well, the whole marketplace of idea of, you know, Todd?
I would argue that in the Pico case, the discussion before the Supreme Court in that case centered upon the arbitrary singling out of a particular issue. So the discussion in that case revolved around.
It was a bunch of books.
A bunch of books.
That were removed from shelves, basically, because the administration didn't like what was in the books.
They were on a
So
list. They were
yeah,
on a list.
so I guess I'm throwing out that, yeah, if we were to do that, if we were to delete free speech from our newspaper here, would we be doing something like that, Nicole?
Well, Pico also argues that the determining factor in whether the school was correct in removing the books or not was their intention. And if their intention was just to get rid of filth that, in their opinion, was considered, you know, disgusting, then that was wrong. Well, what they considered wrong may not be considered wrong to other people. So if their intention was just to benefit their thoughts on what should be allowed to be in the school and what's not, then it says at Pico that they have violated the Constitution.
Okay, but my question is that what's going on here or not? Here, in our case.
I think it is.
Yeah.
I think it
You
is.
do?
Just like the books, they were saying that the books were somewhat anti-American, anti-Christian, anti-Semitic, like she said, filthy. It's almost like the article on freedom of speech seen as like black and white, almost causing or still following the idea of racism and like anti-peace almost.
Oh, Laura.
As the teacher who's recommending that it come out, I can tell you personally it isn't because I dislike the content of it. I'm concerned about the disruption disorder that it may take because of exactly these racial issues. You know, it'll disrupt the school and the students. That's my concern. It's not because I disagree or dislike actually the topic. I thought it was very eye-opening.
Okay, but you just said you're concerned that it was cause disruption. If you're going to, that it might cause disruption, aren't you then also, are you going to the content? Is the reason it might cause disruption because of its content? I'll let you think about that for a moment. Let me hear from some of the students. Michael?
As a student against publication of this, I think a lot of it isn't necessarily the content, but the mixed message of the content. So not particularly the topic. I think an article about free speech and the rights of students would be great to have in the newspaper, but that's not what this is about. This is about the media suppressing news that this student feels is important for everyone to know. And as students, we all have capabilities and ways to seek out the media that we are looking for, and really no one in the school has any control over how the national media operates their corporations. They're their own businesses, and if you don't like the message that they're giving, don't listen. Find a news media outlet somewhere else that's telling the side of the story you want to hear.
Okay, so I'm struggling with that, the fact that, I think you all would agree with me, Hallie Wright herself can express whatever she wants. Unpopular, racist, etc. She's an individual, she can, you know, again, unless she's hurting someone and getting into, you know, what might be bullying behavior, but in terms of her views, I can't touch that. So again, doesn't it boil down to, and that's what I've been kind of hitting Laura about more than anyone, is that we, the school, the administration, can only sort of interfere with that, you know, unless we have the right to sort of, you know, control that. And we only have the right to control that if in some way this after-school newspaper is connected with the school, right? Does everybody agree as to what I just said? Do you disagree, Nicole?
Yes.
You disagree with what I just said? so
No,
tell me
I
why.
agree with
Okay.
to a point with you. The school newspaper is automatically tied to the school. It has the school seal on it. It's, you know, if you hear of a different school newspaper from a different.
No, I did not conclude anything about it.
Okay.
All I said was that the crux of the matter is not what Hallie herself might believe, right? Because she has a right to her own beliefs, however bad we might think they are.
Yeah.
But that the crux of the matter is whether in fact that what she's doing is somehow so connected with school business that the school can actually now interfere. That's what I was saying.
Okay, then to that point then, in section 82, it also says that no expression made by students shall be deemed to be an expression of the school policy, and no school official shall be held responsible in any civil or criminal action for any expression made or published by the students. So her opinion doesn't necessarily reflect what the school may believe and what the school deems is correct for the content. It's her own, you know, article, it's her own opinions, and she's going to put her name on that article, so therefore the school has no liability to it.
But again, isn't there still a question of whether that piece, free speech, written by Hallie Wright, published in our school newspaper, it could be deemed to be an expression of school policy? Jonathan?
No, I think it can be misconceived as such, but according to, and again, as a student in favor of publishing it, according to the Hazelnut, or was it Hazelwood? Hazelwood case, the expression of speech or the free speech has to be allowed so far as to not interfere with the pedagogical purposes of the school, or the ability for the teachers to do what they're supposed to do, which is teach the children. This being published, while it may ruffle some feathers in a sense, it doesn't interfere with the purpose of the school. So, I mean, it's free speech. She has the right to write what she wants to write, and the school just doesn't have the right to bar her from publishing it because it doesn't interfere with the school's mission.
You know, the Hazelwood case also concerned, at that time, the privacy rights of those other students, because there was a student that could be, singled out, pregnant student, like Amanda said the other day. But here's what I'm wondering, if Hallie Wright's article gets published, is it gonna do more than what you just said, Jonathan? Is it gonna do more than ruffle feathers? Is it in fact going to hurt others? Could it be constituted to be some, a form of bullying under the Massachusetts statute? And I don't know if any of you have looked at that yet. Todd?
I would say no, because in the, we're discussing the Hazelwood, school district case, and in that, the school district was looking to protect students who may have been affected by teen pregnancy and divorce, where it's really unidentified here, if any, who the school district would be looking to protect in this instance. And another thing is, in the Tinker case, it called attention to the fact that it was not permissible to go trying to stifle something that may have a detrimental effect, or may get people upset, or may cause trouble in the school. In other words, in the Tinker case, the armbands were, the school district was arguing that they may cause some sort of rioting or some sort of detrimental thing that would be detrimental to the students. In this case, there's no hypothetical, there's no, you can't, the Supreme Court said you can't anticipate something happening, an adverse reaction happening from people that might read it. And in this case also in Hazelwood, they wanted to pull the articles because they found that it would be, they thought that it would be offensive to teen pregnancy. and
Okay,
those
but can
affected
you
by
take
divorce.
that a step further in considering the mass bullying statute? Is it possible that there might be, that Hallie Wright might be targeting groups of students at the school that, you know, may feel like she's, you know, harassing them by publishing that article, Michael?
I would say she does, under section 37O, or is it 370, I don't know, I couldn't tell.
Yeah, 37O is the bullying
Okay.
statute.
Um,
Mhm.
It talks about the written or verbal expression, puts the victim in reasonable fear of harm to himself or danger to his property. I mean, this paragraph right here, most of the violent crimes in America are committed by non-whites. There will be many more gang initiation murders, many people being kicked and stomped to death on the sidewalks of our cities, many more little white girls being dragged behind garages and sexually tortured to death. I think that could put a large population of the student body in fear that these things are going on, the media's not telling them about it, and they should be in fear for themselves.
So let me just read the definition of bullying from the statute. And it's the repeated use by one or more students of a written, verbal, as you just said, Michael, written, verbal, or electronic expression, or it could be a physical act or a gesture directed at a victim that caused that. And then there were 5 scenarios. 1 causes physical or emotional harm to the victim or damage to the victim's property. 2 places the victim in reasonable fear of harm to himself or damage to his property. 3 creates a hostile environment at school for the victim. 4 infringes on the rights of the victim at school. Or 5 materially and substantially disrupts the education process or reoperation of the school. So do any of those possibly apply to the, again, to the possibility of this article being published? Do you want me to repeat any?
I mean, I think placing the
Yeah.
victim in reasonable fear of harm to himself or creates a hostile environment. I mean, the one thing that it sort of hinges on is the repeated use. So is publication of this article a one-time deal and it's never going to be discussed again? Or is this person going around school also verbally telling people, you should be afraid because you're white and you're going to get dragged behind the garage and beaten and raped and killed?
Or homosexual too.
Now, here's my question though, does the school here have to, you know, if I'm looking at the application of the bullying statute, can I just anticipate, as I've just asked, that there might be students or groups of students, you know, affected by the publication, or does it have to be more specific than that? You know what I'm asking?
I think
Because
it needs to be more
in order for it
specific.
to apply, yeah, and that's the problem here, isn't
But-
it? Because in order for it to apply, then, you know, the plan that would be put into place would involve Hallie herself as the perpetrator. There's another word for it, but I can't think of it right now. And then the intended victims. Well, we don't know specifically right now who the intended victims are. So that's why I'm wondering.
All white girls in the school.
I'm sorry?
All white girls in the school are the intended victims. I mean, this is intended to put fear in their minds.
Okay, but is that too vague? Does the bullying statute really apply here? Lauren?
Subsection G, though that statute says, you know, staff members and a number of other people, shall immediately report any instance of bullying or retaliation the staff member has witnessed or become aware of.
Exactly.
And so I think this is, because it hasn't executed yet, it's not witnessed, but it is definitely become aware of. It, you know, if we allow the publication of this newspaper, we are definitely aware of this article within it, and if we believe that this article is bullying, which I agree because of the fear and the emotional turmoil.
Again, is this situation really something that the legislature intended in drafting the bullying statute? Jim?
I would say no.
Why not?
I don't think that it fits. I don't think
Why not?
because she's not, in her speech, although I don't agree with it, she's not supposed to, she's not singling out a specific individual or individuals, and there may be people that read that article that are white, black, or indifferent that agree with what she's saying. So I just don't feel that it has anything to do with the bullying statute.
I'm gonna read it again. Bullying, the repeated use by one or more students, and, you know, the expression is written, verbal, blah, blah, physical or emotional harm to the victim. Number 2, places again, the victim in reasonable fear of harm, blah, blah, blah. Number 3, creates a hostile environment at school for the victim. Number 4, infringes on the rights of the victim at school. And lastly, disrupts the education process, blah, blah, blah. So, are you rethinking whether the statute should apply, Nicole?
Well, I guess you have to look at it from a different standpoint. You know, in the schools, they teach about racism towards, you know, the black people back then. You know, Martin Luther King, we learned about all the horrible things that they endured. We learned about the slave trade and all of that. So if she's going to point out that racism is not just a one-way street and that white people can be, you know, discriminated against as well, then who is the victim here?
You're not answering my question.
There is no victim, because no matter, if you take away their right to speech just simply because it's a publication stating that they're withholding information from, you know, white people being discriminated against, then isn't it kind of the same thing when you're teaching about black people being discriminated against in school as well? Isn't it kind of the same thing? So what you're saying is if we can't publish things about white people being discriminated against, then we shouldn't be publishing things about black people being
In what
discriminated against.
instance would the statute apply? If Hallie Wright was doing, you know, what in the article, Jonathan?
I think if the article was about a specific group, and that specific group was placed in fear, if they were placed in fear through the article, then I feel like that it would be bullying if it was like a repeated conduct. In this case, I think that it's distinguished because the intent of the article isn't to place someone in fear necessarily. It's like not a narrative, but it's describing something that's not you know, brought to light. It's not, you know, directed towards a particular group of people to make them fearful. So it wouldn't be relevant to the bullying statute, or the bullying statute wouldn't be relevant.
Okay, I want to wrap this up, so anybody have any final conclusions or arguments as to any of the sides? Michael?
I mean, I think it's a little, you know, in all honesty, I think it is a little bit of a stretch fitting this into the bullying statute, but I do see circumstances where it could apply. We don't really know the size of these groups. You know, there might only be 30 white girls that go to this school, and that might be a small enough group to feel like it is truly directed at them. You could have someone that was, you know, wrote some sort of threat to the football team, which could have 80 people on it. Doesn't mean that it's not bullying because the group is a little larger. I think you have to look a little more detailed into it. So what I take from it is you can't just make an automatic decision. You have to look at all of the circumstances to see what really is applying here and where is everything, you know, in relation.
Who else? Nicole?
I really don't think that there is a victim here. I don't think it fits into the bullying statute. The only thing that could be a far stretch is that it could disrupt the educational process if people were to be offended by the article. But I don't see that there is a specific target to put fear into to label them a victim. If it was an article about somebody that they changed the names of, you know, like in the Hazelwood case where the girls were pregnant, that's easily identifiable because obviously they're pregnant bellies, you know, that makes them a target. But when it's just generally about just something that's going on, it's not targeting one person. It's just saying this is something you should be made aware of. So there is no victim.
Any other thoughts just in general, not just what was just brought up recently about whether the school should delete or not delete the article?
And conversely, I don't believe that I don't believe that there's a victim. However, no, I guess I could see if it was a predominantly white school and there was only 2 or 3 black students conversely there, they could be targeted as victims as a result of this. It could incite people to be violent towards them.
Again, final thought, should the school delete or not delete this article? Joe?
I think they should delete it. I think it just crosses the line towards bias and prejudice. I think that the school has a right to disassociate itself from that, and I think that also they have a right to remain neutral on controversial issues because they don't want to, be seen as promoting that. So.
Well,
I do believe it is school-sponsored, even though it wasn't part of the curriculum. It is part of the school newspaper. And I do agree actually with what Joe said, is it the disruption and disorder. I think you are trying to keep reasonable relations in a school, and that this is fairly antagonistic, I thought. It wasn't just about the reporting, which is going on in the real world and is an interesting topic, but it was a little more meant to sort of raise the notch to sort of incite conflict, I thought.
right. So what do you all really think? And obviously Hazelwood is really the determinative case. I mean, we talked all around all the others, and even the bullying, which is a stretch, because there is no specific victim, and that's the reason for the legislature, passing this. But it does really revolve around the intersection of Hazelwood with the type of newspaper that's being run here. So I think you all did a great job of arguing either way, because it could be really looked at almost either way, because there is, as Laura pointed out rightfully, there is some control. They're meeting after school. One of the teachers, is their advisor, helps them at it, helps them, et cetera. There might be even school supplies, et cetera. So it's not purely the expression of the students, or it might be deemed to be, as we talked about it, expression of school policy. On the other hand, it could be totally the opposite. No, it's totally the students' views. Where else are they going to meet besides after school, right? And certainly they might be asking, a teacher that teaches English to help them with the editing and whatnot. So I don't think there's really an answer, clear-cut answer to this, and that's why it's a pretty good exercise. So everybody turn over your papers. And now we're going to talk about we're going to get back to the procedural due process rights now of students. So we have, suppose that Randall Roberts sort of, gets up and talks about all this stuff in a speech. He's running for student council. There's a student assembly. He gets up on the stage, blah, 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 blah. As he's saying this stuff, there might be groups of students, saying, yeah, others, want to throw things at him, some are crying, whatever. He gets off the stage, and the administration is saying, oh, do you think he should be disciplined for this? And if so, what kind of discipline should he have? So what are your thoughts on that? Anna? Oops, am I gonna knock down something?
The phone.
Oh, okay. Nobody call 911. Or something else worse. Everybody's thinking. I can hear you thinking. Laura?
So I'm an undecided teacher. If that really happened, that when he came off the stage, people were, I really think it depends on what the reaction was to the students. If it was just his speech, and I'd say he might have had poor judgment and that he was running for student government, but if it didn't incite anything, then I might not go, for any punishment, but if it really did disturb things and it wasn't appropriate to maybe the age level, then, you know, I'd look at maybe detention or suspension. I personally think expelling is not, it's out of line with this speech.
Talk about his freedom of expression in terms of, does he have the freedom to express his views to the student body in this forum, in this context?
He does express his views, he can disseminate his views, and except the only freedom that can be abridged is as long as there's no disruption or disorder.
Okay, Todd had his hand up, or was it Nicole? Somebody did.
And what you had said relative to as long as it doesn't cause disruption. Again, as I brought up before on the Tinker versus Des Moines Independent Community School District, with the armbands, the situation is that the school district cannot anticipate a disturbance. It cannot squelch out his First Amendment right to express himself.
Does it matter that he did it, you know, in the student assembly within the context of that rather than, I don't know, if he handed out flyers after school as students were going home? Does that matter in terms of, again, whether he should be disciplined for saying this stuff? Michael?
I would say it could matter. I think in this particular circumstance it doesn't, because this was a planned, organized event to allow the people that were running for student council to give their speeches to
But
the rest
that's
of the
the
student
point,
body.
isn't it, though? If it was school-sponsored, like, doesn't the school have the right to censure what's said? And is there a certain, like, decorum that must be followed? As opposed to, like I said, if he on his own is, you know, Jonathan, vote for me because blah, 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 you know, as long as I'm not bullying, you know. Or here, take my flyer that says this stuff. Jonathan?
In running for an office of the school, I would say, has the right to, for someone to be elected into that office, for someone to take that office, they have the right to want that person to, you know, in a speech or have views that are consistent with the views of the school. So if that's not the case, then I would say that they would have the right to discipline the individual if they're, you know, causing, you know, like an uproar in the school community, because it's not necessarily a right to be class president or what have you.
Jennifer?
I don't know, I feel like, well, I'm for disciplining him. I don't think getting up and saying a speech that offends everyone really gets your message across if you're trying to get people to vote for you. So that alone, I would say that you should be disciplined. I think that defeats the purpose of what you're trying to do.
John?
Subsection 82 says that the school's views aren't necessarily always the students', and
Right.
the school won't be held criminally or civilly liable. So I don't think there should be any discipline shelled out to this kid for expressing his views. It's his right to do so. You should just leave him alone. I mean, it's right there in the Mass General laws. You're
All
allowed
right,
to
let me
do
up the ante a lot. As a result of what he was saying, there was like a fist fight. He just really, there's no question that there was a disturbance. So whoever was the teacher at the assembly takes him, he's now sitting sort of outside the principal's office. All right, so we're really to the second piece of this. what discipline should be given him? What sorts of rights does he have, Nicole?
Well, as an undecided teacher, it says here that a principal,
Says where were you
in
reading
Doe v.
from?
Worcester, sorry.
Oh, okay, yes, Doe v. Worcester, yeah.
The
Mhm.
principal may choose to suspend rather than expel. However, he or she can only choose to suspend if the opinion of the principal is that the student will pose a threat to the safety, security, and welfare of the other students and staff in the school. So if the students are fist fighting, if there's a huge uproar, if there was clearly a disturbance, then obviously the safety, security, and the welfare of both the students and the staff are at risk here, so therefore expulsion should happen.
Okay, so remember, procedural due process, we talked about this with golf. He's got some rights, right? What are those rights?
Property right, education.
Jonathan is saying it's a property right?
There's a property right to his education, so in terms of his suspension, that's one, so he would have to have, if there were to
Okay,
suspend.
stop for a second.
Okay.
Okay. So let's look at Doe, the superintendent that Nicole brought up. And let's compare that right to the right that Jerry Galt had, and all kids faced with delinquency proceedings today have. Is it the same sort of right? And if that's the case, he's owed an awful lot of due process. That's not the case, right, Todd?
Well, the case with due process relative to the expulsion cases that we looked at for this particular class.
I'm not talking about expulsion. What rights does Robert have in terms of being in school?
He does, on the one hand, he doesn't have a fundamental right
Right.
to a free public education. However, he does have the speech to, he does have the First Amendment right to express himself.
We're past that. Okay, and now in terms of trying to decide whether he has some right to be in school.
He does
So
not.
get past the freedom of expression
Okay.
and get back to the 14th Amendment.
Okay, he does not have a fundamental right to a public education.
Okay, so it's
And-
not like Galt, right? Which was liberty was at stake. And then we've got the Doe case. There's also, and I haven't given you this, as a U.S. Supreme Court case, I think it's San Antonio versus Rodriguez. So there's no, the right is not, but there is some right to be there, right? To have an
Right to
education.
an
You know,
opportunity.
we know an opportunity, we know there's the compulsory education laws that we already looked at. Can't be just told arbitrarily, leave, we don't want you here, right? So there's some right, but the right is so much lower because we're talking about a student versus a kid, you know, I'll say a delinquent or somebody charged with delinquency, right?
I would argue that.
So there's some sort of process that's due, but it's not the kind of process that Jerry Galt gets, which was, you know, the notice beforehand, the right to counsel, the confrontation, the right against self-incrimination. So the process that's due is very little, but there is some process, and that's your Gosby-Lopez case, right? So school kid has some right to be there, right? But that right, again, does not amount to an absolute fundamental right that would merit a high degree of process. However, get some procedural due process. What's the minimal procedural due process? Two things.
The right to be heard.
Yeah, and notice. So there's some kind of notice. But it's not the kind of notice that Jerry Galt gets, right? What kind of notice is it? What does Gospey Lopez tell us?
24 hours notice to mail to the Board of Education.
So there's some kind of notice. So Randall Roberts is sitting outside your office. He's caused all kinds of trouble. Right? It's in the middle of the day. Well, it would be almost the end of the day for them. But it's, before noontime. You want to suspend him, you want to send him home, right? What are you going to do?
I have a
You're the
question.
principal.
I
Yeah.
have a question on that, specifically in the readings that we did for this particular class and the line of cases for the last two classes. My specific question is, on the notice and right to be heard, it looked in the statutes if those were connected to expulsion. If it's something other than expulsion, like, let's say, some sort of sanction against the student, are they?
You're looking at 37H and 37H and a half.
Okay.
Correct.
So are they,
Yeah.
so
Yeah.
are they
Yeah.
entitled to due process even when
Okay,
it's
so
not
right now, we're just
expulsion?
talking about suspension, and there are other processes. Okay, so in terms of sort of the very least case scenario, Randall Roberts, to the most serious, Jerry Galt, and by that I mean kids charged with delinquency or serious offense, you have suspension, you have expulsion. You have another situation, for example, 37H and a half deals with that a child could be suspended and ultimately expelled. Of course, for expulsion, you get more due process, and that's what you're pointing at. 37H and a half, you could have a child that has done nothing in school, but has been charged with a crime out of school, and yet the school can suspend and ultimately expel that student because that student presents, and I forget the exact wording, a detrimental sort of presence affecting the school kids in school. This was spawned by, and I forgot what his name was, but a kid that was charged with murder, and he was out of remember his name. And so just charged. He continued to go to school, and there was a big uproar. Why was he there? Blah, blah, blah. Well, the legislature then wrote the H and a half. That's why you're at 37. So 37H covers instances within the school, weapons, etc. But getting back to Randall Roberts, and Randall Roberts is Gospey Lopez, pretty much, suspension. So it's the very least that I have to do is say, Randall.
Notice of the
Yeah.
allegations. And
And orally, Randall,
Fine.
I just heard from, the teachers at the assembly, you did A, B, C, and D, you're suspended for the week, go home. I give notice, so I'm doing it, I don't have to give him notice as in Galt. I don't have to give him notice before a hearing. I'm exercising the decision and giving him notice at the same time. Okay? Because of the concerns of the school, again, relative to public safety, et cetera, within the school, and again, because it's a temporary suspension, and he's afforded some due process, but the very least notice of. Now, you can be heard. Randall can speak to me right then. He can come in with his parents afterwards, et cetera. The more serious it becomes with expulsion, within the context of, for example, like the girl in Doe v. Worcester, or with expulsion within the context of 37 and H and a half situation, you can have an actual sort of school hearing. You can bring your attorney. You don't have the right to counsel like Jerry Galt, right? So we'll be considering these cases later on, too, when we get into the delinquency cases. Many of the delinquency cases sort of intersect because, kids that are charged with crime, for the most part, they're also attending or supposed to be attending some school. So they may have disciplinary sort of things going on within the school, as well as the Commonwealth charging them with a crime. So, for example, Randall Roberts, in our little scenario, what he's done is he may have been violating a statute in the Commonwealth, disturbing peaceful assembly, this old statute that's still on the books. And kids still get charged with delinquency by reason of disturbing school assembly. So he could be getting this very little, right, procedural due process, you know, you suspend it for 10 days or whatever it is. You give me your reasons, but for the most part, that's it. You're right, you know, I'll hear you, but that's it. You're going home, blah, blah, blah. But if he's charged with it, he's now, a delinquency complaint issues in juvenile court, right? What are his rights then? Jennifer, what are his rights then that are different from his rights in school? You know what I'm saying? No?
Would he be charged with a felony, though? I mean, would that be a felony?
No, it doesn't matter if you're up to 18 years old, but the jurisdiction of the juvenile court is from, for a delinquency offense is actually 7 to 18, and you're violating any statute or ordinance in the Commonwealth, whether it's something that
37H&1 applies to any statute?
No, I'm not talking about H&1
Oh.
now. He's done something in school.
Okay.
All right, he's done something in school.
Sorry, I thought
He's
you were-
disturbed school assembly. Okay. The school suspends him, right? The Commonwealth also files, are you following me? Okay, he gets arrested, you know, the police come and investigate, blah, blah, blah. They say, you know, we're gonna file a complaint. We've had it with this kid. File a complaint in juvenile court. So my question is, what procedural rights does Randall have in the context of the juvenile court case that are different from his procedural rights, read the suspension? Jim?
Well, in that case, I mean, obviously, the notice would still apply.
Yeah, so,
He would have a-
yeah, but he's gonna get the notice, you know, before he's sent to DYS,
Right.
whereas in the suspension, he said, you're suspended, and, you know, you're going home. Again, because his rights to be in school are not as fundamental as his liberty right. So he gets notice. Jim, what else?
Notice that, obviously, a right to be heard, right to counsel, right
Mhm.
to confront witnesses.
When the case goes to trial, there's a right to trial.
Trial, right to a speedy trial.
And what was the last one? You missed one of them.
Fifth Amendment right.
Self-incrimination as well.
Self-incrimination.
So all of that he doesn't have within the context of the school, the school system and with the school disciplinary proceedings, because his rights are so much less within the context of school. Now, one of the cases that I gave you, the kid tried to argue the double jeopardy issue. How is what I just said not double jeopardy?
Because he
So
wasn't exposed.
for disturbing school assembly, he's getting punishment at school and possible punishment in court. Jim?
But one's administrative, the other is criminal. So it would.
I'm sorry, what did you say?
I said one is an administrative type hearing or administrative issue from the court, from the school, versus a criminal proceeding, which is not administrative in nature.
Yeah, yeah, that's Commonwealth v. Stonewall case. I believe is the last in the readings for today. But they so coincide, again, the intersection of, you know, kids charged with crimes, and kids also facing, you know, whatever in school, you know, whether what they committed was in school or out of school. In fact, if you may or may not have heard the term the school to prison pipeline. And one of the types of cases that we'll go over is what used to be the CHINS cases, which are the children requiring assistance, that we actually do after care and protection, where the legislature at least has attempted to try in certain instances when kids haven't committed crimes, but are getting in trouble for one reason or another, are trying prophylactically to offer services to see what can be done, you know, to help kids so that they don't commit offenses for which they could be charged with delinquency. So you could have a kid, you know, Nicole, as I mentioned before, is interning for Anna Elliott, who does delinquency care and protections and CHINS cases. But if the kid, for whatever reason, and so the Commonwealth appoints her as a private counsel, Committee for Public Counsel has certified her to be able to take these cases, and she just bills the state. Here's the problem sometimes. So you say she has Randall Roberts, and maybe there are more issues at school, maybe expulsion, maybe a 37H&1/2 going on. The statute for which she's paid is not going to cover the educational stuff because he doesn't have a right to counsel. I mean, he can bring counsel with him in certain of the school hearings, no problem, but he has to pay counsel, or his parents have to pay. Anybody have any questions on that? Sure, we'll get into a lot of the delinquency cases earlier, but so this is just sort of the end. We're ending today with sort of the framework for really the gut of the course, which starts next week. We start with care and protection cases, which are the cases where parents have allegedly abused or neglected. So the cases about children for which a lot of the framework, like the Prince case, for example, the state can intervene when children are in some, some emotional, physical, etc. danger. Galt follows from that because Galt being sort of the wellspring for children's rights, I'm going to hit the telephone again, Massachusetts, which does grant more rights, right? Appoints counsel for children in these cases, even though they're not criminal cases. By statute, all children get counsel. Appoints counsel for parents as well in these cases. Again, they're not criminal cases. They're cases that deal with custody and possible termination of parental rights. So we'll be doing, covering that for a good portion of the course. And it intersects into so many areas. So for example, we'll be doing a case study or a child sexual abuse case that I had years ago, that intersects also with criminal as well, because you could have the parents that allegedly, or one of the parents allegedly abusing the child also becomes the basis for criminal action as well. Intersects domestic violence, for example, which is also a form of abuse or neglect. We go into issues, for example, the non-offending parent, who's being, say, in a domestic situation, may still end up losing custody because of issues such as PTSD, et cetera, that particular parent has that affects the child. And the obvious ones are also the physical abuse, abuse cases. One that sometimes people don't realize, the medical cases, when for all other purposes, you have great parents, but because Sarah Prince or Yoda that you read, they have some fundamental religious principle that that conflicts with the medical profession's view of how the child should be handled, whether the child is seriously ill or maybe even in danger of losing their life. So that's another form of where you have the state interfering possibly with. So what we'll probably do next week is we'll switch around again what side you represent. So where you guys have been representing the child's view. Let me switch you to the state, to my right. And then you guys in front of me have been,
Even the state,
you with the state? Okay,
Mhm.
then parent, and then to the left will be child, okay? Yeah. On Tuesday, I'll probably be doing most of sort of the lecturing, because I'll go over the care and protection process, so just do your reading the statute, and I think I have an article
Yeah, is
for
there a
you to
statute
read.
in one case or something?
Yeah, I don't even think you have a case for Tuesday. But there's a lot to do in terms of just sort of going through the statute or the pertinent sections of when I say the statute, I mean 119. Did you have a question? Nick?
Do we,
Go ahead.
I don't want to interrupt, do we have a midterm?
No.
Okay.
Do you want one? There are plenty of past exams on file that you could, not yet, once you get through a lot of the care and protection stuff, you could begin maybe to start looking at the past exams, but they cover everything, care and protection, delinquency, gyms, okay? So we ended early, that's why I'm asking if there's any questions or any thoughts. All right, I'll see you Tuesday. Lauren, let me see you for 1 second before we go. Thank you.
Yeah, we have to.
Say like a 14-year-old girl, right? She comes